back to order. Sergeant Arms, please secure the chamber doors. Members, please take your seats. A lot of energy today. Madam Clerk, please call the roll.
Mr. President.
All right, we will substitute the earlier invocation from our Senator from District 11 for this afternoon's invocation. Has everyone recorded their presence? If so, the clerk will take the call. With 44 members in the chamber and a quorum being present, the Senate of Maryland is now back again in session. We are clearly not normally here in August because I feel like I am going to get a sunburn from the sun that is directly right here, which is not ideal. But I say that because we're sort of in summer protocol attire. Well, we're not. We're not in summer protocol attire, which does not really exist. But just want to note, particularly as cameras are on, please make sure to maintain proper protocol. Jackets on when in camera. You can be seen from other sides. So just please keep that in mind. I know it's warm. If folks need to step out to get some air, totally understand. We're going to try and make sure that the air is on the whole time. But just keep that in mind. Proper protocol for the Senate floor when we're in session, and we're going to make it work. We're going to make it work today. That's the theme of this little 2026 special session. So let's see. Are there any, before we jump into anything, are there any announcements or anything that any introductions that senators wish to start off with? If not, let's go ahead and jump in. So we consider the reading of the journal from the prior legislative day. We're going to start with calendar 55 out of Education, Energy, and the Environment. Clerk will read the bill.
House Bill 2101, the Speaker, Arbitration Reform for State Employees Act of 2026, withdrawal and repeal of duplicate proposed constitutional amendment, favorable.
Recognizing Vice Chair of the committee.
Thank you, Mr. President. Colleagues, sometimes we are just too hardworking and too efficient. And last session, we passed both the Senate bill and the House bill for this proposal. And what House Bill 2101 does is simply clarify that there will be only one version of this ballot measure for our constituents to consider in November. There were no amendments. Move adoption of the favorable committee report.
Floor leader moves to the adoption of the favorable committee report. Any discussion? Yes, recognize the minority leader.
Thank you, Mr. President. If the floor leader would just yield for a couple of quick questions.
Senator may proceed.
Of course.
Thank you very much. Madam Floor Leader, obviously this is a very simple bill, just repealing two similar bills that we passed in the last session. But the question came up, what happens if we were not down here in Annapolis for this special session and both of those bills were proceeding? What would actually happen?
Thank you, Senator. There are two options, but bottom line is we don't deal with hypotheticals. We're here specifically the way we are here, but the probability is that both measures would be on the ballots, and there is a possibility that one could be passed, one could be disapproved by the voters, which would be awfully confusing.
Okay, so that's exactly how I heard it. Actually, it would just, everything would move forward. Both questions would be on the ballot, would be very, obviously,
as they are right now on the State Board of Elections website. Both are listed as question number 1 and question number 2 on the state website.
So that was the next question. So I know there's going to be some conversation about the next bill about ballot language and what we call plain language in a Senate Bill 29 that passed earlier in the session. So where is this bill in that process right now?
This bill, the deadline has already passed. The language on the website is the language that we will be, that our constituents would be dealing with. And as you know, Senator, Senate Bill 29 specifically exempts language that we dictate from the General Assembly to be on the ballot, to be going directly from the ballot.
So that's the question then. So when we passed, I guess it was, I just have the House version, House Bill 604, which ended up becoming Chapter 155. It had constitutional language. It actually had the ballot language on the bill, right? Is that accurate?
That's correct.
Okay. And so what's required when we pass Senate Bill 29 about the timeframes being done by July 1st, having a public comment period, Did all of that take place with respect to this bill?
It did not, because we're here now, and that's why we're modifying, because this is about duplicative language, so we only want our constituents to vote once.
But wasn't this bill subject to the July 1st deadline?
This bill is on the website right now. There is, it's exempted because we gave the specific language in the General Assembly in the language that we passed.
Well, again, that's going to be a question as we come up later, because it didn't say in the bill that it's the specific language. It says a question substantially similar to. So doesn't that trigger what was in Senate Bill 29 and making sure that that ballot language has gone before the Secretary of State and then before
Again,
the
Senator,
public?
if it comes from the General Assembly, as we'll discuss when we deal with the next bill, it goes directly to the ballot and is exempted from Senate Bill 29 as enacted by us last year.
So even though this bill was passed by the General Assembly, Senate Bill 29 had not been enacted yet, we're saying that the provisions of Senate Bill 29 apply to this bill,
Senate Bill 29 became effective, became law on June 1.
right?
This bill, therefore, this issue is covered,
Okay. All right, and again,
and that's why we're just trying to get rid of the duplication to not confuse people.
ask another question, if I could, please. When the governor issued his executive order forcing the General Assembly to come down here for a special session, he specifically wrote that we would be adjourning convening a special session for the purpose of passing legislation to amend the state constitution to clarify and reaffirm that the provisions which govern the requirements of our state legislative districts do not apply to Maryland's congressional district. This bill here does not fit within that criteria in which the governor required us to come down, does it?
One of the other things we did was consider and override some of the governor's vetoes. Once we were here, we took other actions, including addressing House Bill 2101 to make sure that our ballot is as clear and succinct as possible for the voters.
Okay, I think that halfway answered my question. Yes, we did come here to do vetoes, but we're required by law to come in here to do vetoes. That's not whether the governor, forces us to come down here. He well recognizes in doing so that we have to take up, as the first order of business, we have to take up vetoes.
Correct.
So that was a requirement. He doesn't need to list that in his executive order, but he did specifically say why he's sending us down to Annapolis. And this bill, I don't know that this bill fits within the criteria that he sent us down here for.
Just to clarify, Senator, it was the presiding officers, the President of the Senate, and the Speaker of the House who first called for the special session and convened us. The governor then added on his opinion and shared his executive order, which is great. It just shows we're all on the same page and
So
ready to
there
do the
was-
people's business.
There was an announcement from, an official announcement from the Speaker and the Senate President forcing us to come down here?
I wouldn't use the word force, but
That's what it is. I mean, we
convening a special session, and then in subsequent communications with all of us and with the general public, they made clear that the order of business is going to be redistricting. Having said that, the first time we convene after we've adjourned sine die, veto overrides are the first item on the agenda.
Right,
Now,
but this
because
isn't a
this
veto
bill-
override.
That's true, Senator, but as I was going to say, because that measure deals with a ballot measure that the voters will be considering in November, as this one does. House Bill 2101, it was timely, it was brief, it was supposed to be non-controversial, it's an administrative measure and just cleaning up the ballot.
Okay, so essentially then, the statement was as long as it deals with the Constitution, that you think that is acceptable for falling underneath the governor's requirement of why we're being convened down here.
I can't speak to that. The
I thought- no,
presiding
I
officers are...
was
the
just
presiding-
summarizing. I thought that's what you said.
The presiding officers have set the agenda, and we are considering the items before us, including this one, which is
Okay.
an administrative cleanup.
Okay, it just, it has just been obviously quite controversial on why we're down here and what we can and can't do. You're right, the presiding officers did issue a memorandum talking about this legislative session, but essentially that's when they came about and say that they would not allow Department of Legislative Services to draft any bills that don't specifically relate to congressional redistricting. And so that's why I was asking the questions about this, because none of us, anyone else, had the opportunity to have any other bills drafted for this special session. But obviously, that didn't apply to everything. And that's what was concerning, because again, as everybody knows, it's election year. Everybody's out campaigning. Everybody's talking to their constituents about what do I need to do to go back and get reelected. And constituents, at least what I'm hearing, are not talking about redrawing maps and legislative redistricting.
So I'm not especially hearing a question, but I just want to remind you that the presiding officers are elected by the members of each body, the Speaker of the House and the President of the Senate. They have set the agenda, and the governor is a co-equal branch of government. The legislature sets its own agenda.
Okay, and I think that's what the presiding officers did by saying that Department of Legislative Services will not accept any bills to be introduced in this legislative session unless they specifically relate to congressional redistricting. But as we're seeing, there was another bill that was introduced that didn't follow that guideline. And so that's what the concerning part. And again, when we go back to what we're talking about and what we're hearing back in our district, it's people want to know, if we're down here, do we talk about the issues that's most important to them? And again, I don't know, maybe in your district it could be different, or somebody else's district it may be different. We're not hearing that the most important issue to Marylanders is redrawing congressional maps. What we're hearing is it's the cost of energy, it's the cost of housing, it's affordability issues, it's the gas, it's taxes, all of those things, DDS, self-directed care, all of those things are what we're hearing about when we go out there. So it was, again, we've made it very clear. It was unfortunate that we were not able to address the issues that are most important to Marylanders, and in a sense, we're coming back to do this. But I just did want to point out that, again, the governor called us down here for a very specific reason. And, again, the first bill that we deal with is really not within what his direction was to us. And I understand it needs to be done. We don't want to confuse the voters and have two of the exact same questions on the ballot. It would make it look like we don't have everything exactly together, but we're going to fix that. And again, I think we're going to talk a little bit more about ballot language, plain language. We're going to talk about timeframes for public comment. We're going to talk about where the Board of Elections are in the process right now. And Senate Bill 29 that we thought was so important to pass in January, and how that relates back to the bill that we're going to talk about that. So with that, Mr. President, thank you very much. Madam Floor Leader, thank you.
All right, question remains on the favorable committee report. Any further discussion? Any objections? Without objection, the favorable committee report is adopted. Are there any amendments to the bill or its title? Seeing none, House Bill 2101 is hereby ordered passed for third reading. Let's go to report number 54. 54. Clerk will read the bill.
House Bill 2100, the Speaker, Election District, General Assembly, and Representatives in Congress, favorable.
Recognizing the chair of the committee as the floor leader.
Okay, thank you, Mr. President. Okay, House Bill 2100, in a nutshell, is a proposed constitutional amendment approved by the voters at the next general election, establishes, number one, specified provisions of the Maryland Constitution regarding legislative districts that apply explicitly to the election of members of the Senate and House of Delegates. Number two, Mr. President, states that nothing in the Maryland Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional districting plan. And number 3, the General Assembly has the power to grant original jurisdiction to the Supreme Court of Maryland to review the congressional districting plan of the state. The bill also specifies language for the ballot question to be submitted to the voters at the November 2026 general election, notwithstanding any other law. There were no amendments, Mr. President. I'd move adoption of the favorable committee report.
Floor leader moves for the adoption of the favorable committee report. Any discussion on the report? Yes, I recognize the minority whip on the report.
Thank you, Mr. President. I wonder if the chair would yield for a question.
I will. Might the gentleman, perhaps, I was really planning to give some background about the bill and then yield to some questions, just for some
Once
context.
we adopt the report.
It's relevant to the report, it's relevant to the bill, and then I think it would be constructive as I lay out some of the background about the bill.
Okay.
Your questions might be more germane and maybe more targeted. So, Mr. President.
I would
the
yield
indulgence-
on that for the opportunity for us to come back. Yes,
On the report,
thank you.
certainly.
Okay, thank you, Mr. President, for the indulgence. So before we get into some Q&A, I just want to make some comments and background, which I do think is very, very important for this piece of legislation. So number one, Mr. President, I do want to clarify, because we all get emails about information, some information, and there is some confusion out there. So let me clear up one thing. During the regular session, the House attempted to move a bill that included a redrawn congressional map. Today, Mr. President, there is no new map before this body as part of HB 2100. Let me repeat that. We are not creating any new map, so any criticism about hypothetical future maps is entirely premature. That's a debate for some future date, if ever. And secondly, Mr. President, equally, if not more important, is I have to feel compelled to remind the body, so if this constitutional bill does pass, it must go to the voters of our state to approve or disapprove. And so there will no doubt be media, political campaign for and against. It's the voters of Maryland. The voters of Maryland will have the last word. As for House Bill 2100, all it really does, in a nutshell, is it clarifies an issue that was not really thought to be in dispute for over 155 years, namely that the state constitution governs the standards for drawing state legislative maps, and the United States Constitution and federal law applies to congressional district. Now, at the heart of this discussion, and I'm sure we're going to have some back and forth on this one, but at the heart of this discussion is a very narrow provision in our state constitution, Article 3, Section 4, which lays out standards for, quote, legislative districts. And beginning in 1867, when that phrase was first originated, and for the next 155 years, that phrase was historically and consistently interpreted to apply only to state legislative districts, not congressional districts. An interpretation, Mr. President, based on principles of constitutional construction involving other provisions within Article 3 itself, which clearly distinguish between state legislative districts and congressional districts, other articles in the state constitution, and several constitutional amendment efforts where the phrase legislative district was in play in the context of redistricting. To be more specific, Mr. President, the plain language of Articles 3 and 5, because I mentioned Section 4, but if you look at Section 3 and Section 5 of Article 3, the two provisions right before and after, they expressly, Mr. President, expressly refer to legislative districts in the context of state Senate and House of Delegates districts. There is no mention whatsoever of congressional districts. We have other articles in the state constitution expressly use Congress for federally related provisions. I would note that Section 5 of Article 3 requires state districting to be introduced as a joint resolution, whereas congressional districting is introduced as a bill subject to veto by the governor and does not follow procedures described in Section 5. And then in terms of constitutional background in our state, Mr. President, if you go back to the origins of the phrase legislative district, you go back to 1867 Constitution, when Baltimore City was divided into legislative districts, each electing its own senator and delegates. Moreover, there was constitutional amendment efforts where this issue was in play, as I mentioned earlier, in the context of redistricting. We had the Eney Commission in the late 1960s, which resulted in a constitutional convention which specifically proposed a draft constitution proposing the same redistricting standards for both congressional and state legislative districts. And that proposal, Mr. President, was overwhelmingly rejected by the voters of the state of Maryland. Also relevant, Mr. President, by way of some historical context in terms of constitutional efforts, you can go to 1970. A constitutional amendment dealing with reapportionment of the Maryland General Assembly into different districts for Senate and House delegates described them as legislative districts. And in 1972, Mr. President, the Maryland Constitutional Amendment there adopting the current system, also called senatorial and delegate districts, legislative districts, which brings me to March of 2022, when, notwithstanding the 155 years of Maryland constitutional and legislative history, one single lower court circuit court judge in Anne Arundel, in the context of reviewing a specific map, did muddy the waters with a decision not reviewed by any appellate court, including our Maryland Supreme Court. In that time, the court was called the Court of Appeals, and a decision that has no precedential value, no binding effect, and it applied state constitution to the congressional map for the very first time in the 155-year period. But in so doing, Mr. President, if you review that decision on page 16, the judge very specifically says the language is very ambiguous. As is in the case, Mr. President, let me just close in making this point, of law, when there's legal ambiguity and clarity is needed, the legislature, that's us, often steps in to provide much needed legal clarification, legal certainty. And House Bill 2100 does just that. It respects the at this point, 160-year legislative constitutional history of this state that I just mentioned, and went through the will of our Maryland voters in prior constitutional amendment efforts by providing the needed constitutional clarification, certainty, and that the term legislative district, and by extension Article 3, Section 4 standards, and the state constitution more broadly, apply to state legislative districts, not congressional districts. This clarification, finally, Mr. President, as I said earlier, if passed, will still need to be validated by the voters of our state in November. And with that, Mr. President, I will yield for questions.
Thank you, Mr. Chair. To the minority whip. Nope. Defer to the senator from the 42nd.
Thank you, Mr. President. I wonder if I might ask some questions of the floor leader.
Senator may proceed.
Yes, sir.
Thank you. I'm looking at House Bill 2100 on page 2. Lines 23, 24, and 25. It says, nothing in this article or elsewhere in the Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional district plan. Can you tell me which of the articles in the Declaration of Rights are impacted by this language?
Well, I would suggest, and we go back to this Battaglia opinion from 2022, where she did invoke this novel theory that those come into play. I would say that from 1867 to 2022, the general view was that these state constitutional principles or provisions have no application to congressional maps. And so I would say that none of them have impact, notwithstanding one lone Anne Arundel Circuit Court judge decision that had a different opinion. I would also say, Senator, that's very subsequent to that decision, the Court of Appeals opined that decision was highly problematic and I think I would say, if not implied or expressly kind of rejected that those principles would apply to congressional maps. So I would say this bill is about clarifying what was thought to be the law for literally 150, 160 years, and that the provisions of the Declaration of Rights or for the state constitution as a whole do not impact congressional map making. And that is basically what House Bill 2100 is all about.
Okay, let me come back to my original question. I'll try to rephrase it and see if I can't get a more specific answer. This bill would amend the state constitution and then put into the state constitution the following language. Nothing in this article or elsewhere in the Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional district plan. So my question is, what are the specific articles in the Declaration of Rights that this particular language is intended to change to exclude their application to congressional redistricting plans?
I don't think it's intended to change anything. There are 3 provisions in the Declaration of Rights were used by that one judge to then take Article 3, Section 4 and say, because of these 3 provisions, legislative district means not just state legislative districts, but congressional districts. And the weight of the last 150 years suggests that that was misguided. And so to take those provisions in the Declaration of Rights that she cited, and then went and took that to interpret that to mean that somehow Article 3, Section 4, legislative district means congressional districts, when in fact 160 years it was never included to be that. So I would say, again, we're not changing anything. We're just clarifying what has been, and we believe has been the law the entire time. Now, those provisions would apply to state legislative maps potentially, but not congressional maps. That's the only issue that we're dealing with in this piece of legislation.
So I think you've averted to the 3 articles that were referred to by Judge Battaglia and her opinion of a couple of years ago. That was Article 7, Article 24, and Article 40 of the Declaration of Rights. So is what you're telling us that despite Judge Battaglia's opinion that those 3 articles of the Declaration of Rights impacted congressional redistricting, the purpose of this amendment is to make it clear that those articles in the Declaration of Rights will not apply in the future to any court considering whether a congressional redistricting was constitutional or not?
I think that's accurate.
Okay, let's talk about the 3 particular sections. So Article 7 of the Declaration of Rights is known as the free elections provision. It reads in relevant part that the right of the people to participate in the legislature is the best security of liberty and the foundation of all free government. For this purpose, elections ought to be free. Judge Battaglia found that language impacted the congressional redistricting, which she believed had the effect of rendering our elections for Congress in Maryland unfree. You're saying that the purpose of this amendment is to make sure that in the future the Declaration of Rights, specifically Article 7, no longer applies in cases of congressional redistricting, right?
As I'll restate again, that is correct, because that's how it was viewed for the 155 years before. That one single lone opinion that was never appealed, never subject to review, and in fact subsequent case law has cast tremendous doubt on that whole rationale that you just cite. So you can cite to one lower court decision that has no binding precedent on anybody, and that's really that you can cite to that, but there's nothing before or after it to support that principle that you, I think, are trying to kind of lay a foundation for. Again, this is clarifying, not changing what we believe to be the law of the land based on constitutional amendments, the origins, other measures that have happened since 1867 when that term legislative district came about.
Well, let's continue on this dialogue. Article 7 of the Declaration of Rights has never before been ruled by a court not to apply to anything that the General Assembly does. These are the inalienable rights of the people of Maryland as formally set forth in the Declaration of Rights, which has been given equal effect to the state constitution. And what you're suggesting is that once this amendment gets passed, this particular article of the Declaration of Rights, the right to free elections, will no longer apply to congressional elections. Is that what you're saying?
It'll apply to state legislative districts, state constitutional principles, including those Declaration of Rights. But again, based on the history of this state, going way back, it will not apply to congressional map making.
So you're going to amend, the General Assembly, if it passes this, then it's ratified by the voters, the Declaration of Rights, specifically Article 7, guaranteeing free elections, will no longer apply to congressional elections in Maryland, correct?
Well, as the judge herself set forth on page 16 of her opinion, that this whole connection between what you just referenced in legislative districts and is very, very ambiguous. She specifically says that, and in fact, I would suggest, as I mentioned earlier, the role of the legislative branch is to remove ambiguity where there's need for clarity. And in this case, I think she's crying out with that opinion on page 16, please, General Assembly, give us some guidance, because I don't have any guidance to go with this ruling going back to 1867 and subsequently, whether it's law review articles from appellate judge Dan Friedman and other people that have been highly critical of that. So I know that you're going to continue to cite to that one lower court, Anne Arundel County Circuit Court opinion, but that's basically what the bill does, and so I don't really have that much more to add.
So, but if this amendment is passed, the case is closed. No, not only will that particular, by the way, Judge Battaglia is a former Maryland Court of Appeals judge who, because she turned 70, had to step down from the court, and she was sitting specially in the circuit court. So let's not diminish the importance of Judge Battaglia or her opinion. So if this goes through, neither Judge Battaglia or any other circuit court judge or the Maryland Supreme Court, none of them will be able ever again to rely on the Maryland Declaration of Rights, Article 7, when considering whether or not congressional redistricting is constitutional. Accurate?
You just read the whereas clause. I think it's pretty clear.
Okay. Let me go on then to another article in the Declaration of Rights. Article 24 is known as the Equal Protection Provision. It reads in relevant part that no man ought to be disseised of his freehold liberties or privileges, or in any manner destroyed or deprived of his liberty. That has applied ever since 1776, when the Declaration of Rights was enacted. And what I understand based on the language of this particular bill is from now on, that provision, one of the inalienable rights of the citizens of Maryland, not to be disseised of their liberty, will no longer be applicable with respect to congressional redistricting. Is that correct?
Yes, I'll reiterate that the three provisions that Judge Battaglia cited in the Declaration of Rights, and then by extension tried to apply that to the term legislative district in Article 3, Section 4, those simply are not going to apply to congressional district map making.
Okay, last of this line of questions. Article 40 of the Declaration of Rights is known as the freedom of speech provision. It reads in relevant part that every citizen of the state ought to be allowed to speak. So, do I understand that the language of this bill is going to remove from Marylanders their inalienable right to speak with respect to congressional redistricting? No longer will courts be ever able to refer to Article 40 of the Declaration of Rights as protecting the rights of the citizens of Maryland in connection with congressional redistricting. Isn't that correct?
I don't know, inalienable, I mean, people get to vote. I mean, people have all kinds of inalienable rights.
Declaration of Rights specifically uses the word inalienable.
I understand that phrase is a broad term. We can debate what, I'm simply saying that the Declaration of Rights, those three provisions, again, were never used to apply to congressional map making. And you do, as I say again, cite to those three provisions she relied on to come up with her decision in March of 2022 that was never appealed to our appellate courts and has no precedential value.
So, by your admission, these three articles of the Maryland Declaration of Rights will be basically read out of the law of Maryland as respects the constitutionality of congressional redistricting.
Not state legislative districts, but with respect to congressional. That is correct.
Right. So now I'm looking at page 3 of the bill, which, as amended, would require the following language to be put on the ballot so the people of Maryland will know what they're voting for when they go to the polls. And it says, the proposed constitutional amendment clarifies that certain standards in the Maryland Constitution apply only to districts used to elect members of the General Assembly, authorizes the General Assembly to grant original jurisdiction of the Supreme Court of Maryland to review the congressional districting plan of the state, and requires the criteria for boundaries of congressional districts to be determined by applicable federal laws. No mention of the Maryland Declaration of Rights, no mention that the inalienable rights of Maryland citizens will be taken away from them if this bill gets passed by them in the fall. Is that accurate?
This language is what we, I think, believe is the, has been since for 155 years, the law of our state. And so it's not changing anything, it's just clarifying and putting it in front of the voters. There can be, let me just make this point, you know, unlike a regular bill we pass, we do have a backstop called the voters. And whether it was, you know, in 1969 when they rejected an attempt to conflate congressional and legislative districts to have the same standard, they rejected it. There's precedent. The vote, there will be clearly probably some kind of campaign here to try to vote down this referendum, and we'll let the voters of our state determine one way or the other whether to adopt this this particular constitutional amendment. And this language, we believe, is a clarifying amendment, not a change to anything.
But wouldn't you agree it is absolutely essential in a case like this, if we're proposing that the inalienable rights of the people of Maryland are going to be impaired by this particular constitutional amendment, that they be fully informed about what they are voting on when they go to the polls? The fact that there's no mention of the Declaration of Rights in the information that's going to be provided to them is inexcusable. Wouldn't you agree with that?
No, I would say I would not agree. We're not taking anything away from anybody. We're simply clarifying and a much needed ambiguity in our constitutional system that Judge Battaglia herself acknowledged, and we're doing the clarification here. So nothing's being lost, nothing's being changed. We're restating what we believe based on constitutional construction, other parts of Article 3, Section 4, some of the constitutional amendments I referred to earlier, and so you keep referring, I should say you, Mr. President, my apologies, the senator from the 42nd District keeps referring to losing this, losing that. That is not what this does, and that's not, the folks, that's really all I can add to that. That is, there's no loss of anything here. It's simply restating and clarifying, subject to the review of the voters of our state, which in the past have rejected constitutional amendments.
Let me ask this. Can you can the floor leader point us to any other instance in the entire history of the state of Maryland when the voters have been asked to give up the inalienable rights that are guaranteed to them in the Declaration of Rights? Has this ever happened previously?
Okay, I'll just restate. The voters of our state, the citizens of our state, the residents of our state are not giving up anything. Again, with the exception of one circuit court judge, a respected jurist, I'm going to acknowledge, in one case in March of 2022, there's nothing in Maryland history before that opinion or subsequent to support the fact that the state constitution should apply to congressional district map making.
You would concede that under the current language of the Declaration of Rights, which was, as indicated, enacted 250 years ago, there is no exception for congressional redistricting. So what we're doing now is importing that exception into the Declaration of Rights. And wouldn't you agree that when we do that, the voters will be giving up the rights to rely on the Declaration of Rights if they should decide to contest congressional redistricting? Isn't that the case?
I don't think there were even congressional districts in 1776, but let's put that aside. We can go back and forth on this. I just would kind of, again, reiterate sort of just the basic principle that we even had constitutional amendments where the voters were asked, do you support applying the same standards for congressional map making as legislative districts? And the voters overwhelmingly rejected that constitutional question. So I'm sort of at a loss to know how much more I could add to that very basic principle, going back to 1867 and before we even had congressional districts. You're citing to 1776.
Well, let me just conclude with this final question then. Would you not concede to me that it would be an adequate ground for contesting the constitutionality of this amendment because the amendment never mentions to the voters who are asked to vote on it that the Declaration of Rights of Maryland is being amended by this amendment in a way which will deny to the voters the rights contained in Article 7, Article 24, and Article 40.
Okay, Marylanders or anybody else in the United States can file a lawsuit making a number of legal claims, and that will be ultimately up to a court to decide. That's beyond the scope of what this body, I think, is equipped. I think for our purposes, our role is when there's a legal ambiguity, in this case actually cited by the judge herself that you keep relying on, it's up to us. I think we have an obligation, to be honest with you, to come in and provide the certainty that I think is required, and I think that's what we're doing in House Bill 2100.
But the voters are not being informed that there is an ambiguity in the Declaration of Rights. And the purpose of this amendment is to clarify that ambiguity by making sure that they no longer have the protections of the Declaration of Rights in these situations. The voters are not being told about that.
I remember when we had a 4-hour debate on the Utility Relief Act, I used the objection from my former Justice Department lawyer days about asked and answered and that kind of thing. I mean, I'm starting to get into that same realm here. I really don't have that much more to add, Senator.
Okay, thank you for your answers to my questions.
Thank you. Recognize the senator from the from Baltimore City, Baltimore County.
Thank you, Mr. President. Would the floor leader yield for some questions? Thank you.
Yes.
Proceed.
I'm also interested in clarifying, I think at this point, help us clarify exactly what the Maryland Declaration of Rights sort of was intended. So it's my purpose, or my understanding, that the purpose is to establish explicitly just some fundamental liberties for individuals, some inherent freedoms, again, for citizens, and government overreach. Is there anything beyond that is in the Declaration of Rights?
I think that's a fair description.
Yeah. And then the article, and it's right, there's 3 different articles, and so there's Article 7, which you'd agree has been paraphrased and used as a theory of law, both by the court, and by the opponents, to call it a right to free and fair elections. But doesn't Article 7 read that the right of people to participate in the legislature is the best security of liberty and the foundation of all free government? Is that a statement? Is that a direction about drawing lines or redistricting, or does it prohibit and take away anything from citizens in this regard?
Yeah, it doesn't establish any kind of a criteria or standard of any sort, which is the subject of this piece of legislation. So it's that's pretty much how I see it.
And doesn't it say that every citizen having the qualifications prescribed by the Constitution ought to have the right of suffrage? What is suffrage? What is that?
Okay, I'm not sure that is about standards for congressional map making. I don't see it that way. I think that's another principle within those Declaration of Rights, which, by the way, will still have application to state legislative districts.
In other words, is there anything, that's what I was asking, is there anything, in this bill that would take away suffrage from the population?
No.
Yeah. And then 24 article, you'd agree that it says no man ought to be taken or imprisoned or decised of his freehold liberties or provisions, or outlawed or exiled in any manner, destroyed or deprived of his liberty or property. Is anything in this article, when we say that this doesn't apply to congressional districts, are we now
Look, I don't want to go down into novel theories from litigants. I mean, people use all kinds of things, and folks in the future could try all kinds of things. I'm trying to focus on the here and now. What's the issue before us? What this piece of legislation, constitutional amendment, seeks to do, and not stray too far into potential novel theories that folks can float.
Yeah. Yep.
And that's kind of where I think I'll leave it.
and the final one that's been raised, that's been interpreted again as a theory of law, but it is not actually in our Constitution, but it's been used as a theory of law and is being presented by the opposition as the actual Declaration of Rights. But Article 7, the actual language is that the liberty of the press ought to be inviolably preserved, and that every citizen of the state ought to be allowed to speak, write, and publish his sentiments in all subjects, being responsible for the abuse of that privilege. Is there anything in this constitutional amendment that takes away the right of the press?
I don't think so.
Okay. Well, thank you. Thank you for clarifying
Okay, thank
the
you.
applicability of the Declaration of Rights.
All right, thank you. Recognize the senator from the 37th, followed by several others.
Thank you, Mr. President. And I just had a question for the floor leader about the
Will
report.
floor to yield. Senator may proceed.
Thank you, and I appreciate the debate. A lot of deep constitutional concepts, but yeah, this is my home we're talking about. I don't think there's any, I mean, everybody should know this. We're talking about the 1st Congressional District. That's the Eastern Shore, Harford County, part of Baltimore County. It's my home, it's where I grew up, and I've got a lot of history with things there. And specifically about that report, I want to get into that later, but right now for this report, just wanted to understand exactly the practicality of what is in that report. So with the report, does this mean in the future, if this should become a part of the Constitution, that are there any requirements remaining for how a congressional district map will be drawn?
Yes, I mean, I think it's in the bill, but the Constitution of the United States of America, Voting Rights Act, Equal Protection, any aspect of federal law will all be part of that review. And so the congressional map making is still subject,
Right.
as is set forth plain language in
Right.
House Bill 2100, will still be fully subject to all those provisions.
Right. So they'll all be in that bubble. Now, looking at the Eastern Shore, so there is no when this becomes part of the Constitution, there's no requirement that there's a geographical connection in that district. Is that correct?
No, I would point this out. One of the, and I'll read it to you, I think is relevant. I mean, it's not binding, but we do have whereas clauses. Specifically, if you look at page 2, it says, whereas preserving Maryland's cohesive communities of interest connected by shared civic, social, economic, political subdivisions, and other common interests without unnecessary fragmentation is a legitimate neutral consideration in congressional district making. So this isn't in the body of the amendment, the Constitution, but it is instructive that as these reviews go forward, these are legitimate considerations in congressional map making, some legislative intent of sorts. So this bill is not completely ignoring what you're saying. I'm just suggesting that it's, you're raising a couple of, the main review of those maps will be under federal constitutional law and federal law. And, that whereas clause at least puts some framework and context on this piece of legislation.
Go back and took the whereas clause is on the second page. Was that?
Yes, on the top of page
Okay.
2.
And so in the court case, though, wasn't the Bay Bridge the problem?
What court case are you referring to?
The most recent court case that challenged the drawing of the 1st Congressional District map, the Battaglia case that we've been talking about for the last 2 days.
Okay. I don't remember. I mean, my focus on that opinion was on this whole issue of what standards apply to congressional maps, state legislative maps, Article 3, Section 4 of the Maryland Constitution. So the impact of the Bay Bridge, how important that was in her, I believe, I don't know how many 50-page opinion or something. I don't recall if the Bay Bridge was the dominant topic for her.
I just think I need to know. I want to know. I think my constituents deserve to know. To my understanding, that Bay Bridge was the problem, and I think it's very clear that this is being done, at the direction of Governor Moore. He's been talking about it for a long time. We had that, I don't know what you call it, the Kangaroo Commission that drew the last map that nobody wanted to move forward with, right? And so here we are now, and we're talking about the 1st Congressional District. So, you know, if the bridge is now going to be acceptable, I think we should know that. And more importantly, you know, as a child growing up, my congressman for 10 years lived in St. Mary's County. I don't think he knew half. I mean, it was very, very sad. It was I don't know how many people in this chamber were represented by a member of Congress that you couldn't reach, that didn't come home, that was never around. I mean, we knew Louis Goldstein and Governor Schaefer better than we knew our congressman. And I just want to know, with this new standard, if now all of a sudden, is it going to be permissible to recreate that congressional district back to the way it was in the 80s, or are we talking about just going back to what I refer to as the Kangaroo Commission map is, with the bridge that goes across?
Well, a couple of things. Number one, I had to say this at the outset because, again, I get emails about you guys are doing a map to mess up the Eastern. There is no map. And a lot of the debate that we might have potentially, if ever, in the future, will bring some of those issues, the impacts on the Eastern Shore and the like. I would also know you about geography and I mean, I do think the current congressman from the Eastern Shore, he used to be a senator from Baltimore County. I mean, this issue that if you live in Baltimore County, you can't represent the Eastern Shore. I mean, you can take it a little too far, but the reality is, until we have an actual debate about an actual map, I think some of these issues or concerns are premature. And that this year, this chamber, there was a bill in the House of Delegates with map. And we made a decision to slow play this, clarify the rules of the road, and not entertain a map. And therefore, I would say that some of the concerns that are being raised, although I hear you, they're legitimate, but I think until such time, again, if ever, we have a debate about an actual map, I think some of the concerns are premature.
Well, I have the utmost respect for you and your patience and the time and going through all the specifics of this. I will point out, though, the congressman who was in Baltimore County, he was there for a couple terms and then figured out he wanted to be on the Eastern Shore, so now he's lived in Cambridge, right in Dorchester County, for quite a while. But you know, it's clear what's going on and what we're talking about, and it's a directed political move right out of Washington, D.C. It is the disenfranchisement of people voters who live in that 1st Congressional District. And I just wanted to try to clarify, so they understand how this process is working. And I think the answer is wait and find out. Wait and find out. Now, that's sort of, we've been given some vague answers. You've done a really good job. I really appreciate it. I appreciate your patience. But when your voters, your constituents are being disenfranchised, it is a fundamental, I mean, this is at the core of our Declaration of Independence. It was a part of our revolution. The Eastern Shore is home to the Maryland 400, right? You're striking a lot of chords, and there's going to be a lot of animosity over what's being done right now. I mean, it is directed at one specific group, and there's a lot of history and a lot of things are involved. And I just want to make it perfectly clear, when you're disenfranchising folks, at least we need to be able to tell them how we're going to disenfranchise them so they understand, what is actually being done. I understand there's some underlying concepts, and I know this is a discussion for later on in the bill, but my specific question was in regards to the geographic connection, any kind of foresight on how that's going to play out. I think the answer is the governor has said he's going to take out that 1st Congressional congressman, so wait and find out. So,
yeah, I can't speak for the governor. The governor speaks for himself. We have in front of us a piece of legislation, constitutional amendment. That's all that's in front of us.
Well, I appreciate your answers because you have spoken for yourself, so thank you, sir.
Thank you, Senator. All right, any further? Yes, recognizing Senator from District.
I'll go ahead.
All right,
Sorry.
Frederick County.
Sorry, Mr. President. Thank you.
Please.
If the floor leader would yield just for a few questions, please.
Yes, sir.
Thank you for taking the questions. So I just am curious, why not appeal the decision from 2022 that this is apparently all starting from? Why not appeal that decision? Because isn't that a procedural part of our? It would.
My recollection at that time was this map was struck down, and then there was a some kind of arrangement with Governor Hogan to come up with a new map and avoid more litigation. And as a result of that, there was no appeal taken. But that is one of the reasons why this particular opinion was never really reviewed by a higher court. So I think you were serving here. That's my recollection about what happened. So you
Yeah.
say why? I think it was part of a discussion and negotiation of sorts.
Yeah, I agree that there was nothing that prohibited an appeal by this body, by any member of our state, really, to appeal that decision. And
I'm also not the Attorney General at that time, and so I don't want to get into what may or may not why. I'm just giving you the facts as you
No, I
recall
appreciate
because you were
that.
serving here.
I appreciate that. I just want to lay out the foundation that there was a recourse in place available that was not exercised. So there was no failure by the design of the current Constitution or the three-legged stool, if you will, with the judiciary, executive, and legislative branches to continue to problem solve this through the courts. They just chose not to.
Well, I think I pointed this out earlier in a case later that year. Wasn't an appeal from this decision, but in the matter of the 2022 redistrict, there was a Court of Appeals decision subsequent. I'll read it to you. In the matter of the 2022 legislative districting of the state, an opinion that was roundly critical of that lower court opinion from Judge Battaglia. But I hear you. I think that was part of back to my original point. Map was thrown out. Negotiation resulted in a new map, and then we moved forward because, again, there was an election, and I think there were some concerns about having knowing whose districts or what districts, and you need some clarity. Back to this thing, you need clarity in the Constitution when it comes to the map making, legal clarity, constitutional clarity, and that was not the case then, and we're trying to clean it up now.
So legal clarity can be determined through the appeals process. That's why we have it. Is that correct?
Good, but the General Assembly plays an important role. I will say this again, we have multiple sectors, not outside of election law, every other phase of our life where whether it's a court citing ambiguity or just we come to conclude that a piece of legislation is unclear, this body can step in and clarify it. And that's what we're doing here. Whether it doesn't have to be, yes, a court can take an appeal and render an opinion, but quite frankly, I think from a policy standpoint, we have an obligation to step in when we can to do it ourselves.
Okay, thank you for that answer. And I'm just curious, you brought up about the 155-year history, the constitutional history regarding this specific subject. And I'm just curious, during that same time frame, has this body ever done something to take away a citizen's right of appeal?
Is that argumentative? I mean,
No, I'm asking a question. Have we ever taken away a citizen's right of appeal for any particular
there's
section
nothing,
of law?
okay, let me just be clear. There is nothing in House Bill 2100 that takes anybody's right to appeal away. So I'm not quite sure what the gentleman's reference is to that.
So
It's
I
an
guess
enabling piece of legislation. And again, there's no map. It's enabling no right of appeals being taken away by any Marylander.
So I'm not trying to be
Judicial review.
I'm not
It's still
trying to
intact.
be. But the judicial review can only be triggered by whom? A citizen or this body?
Okay, judicial review, any person that's a litigant to a litigation, if they lose, they can appeal to a higher court. I mean, that's the way our system in the United States. Maryland's not unique in that regard. Federal court, in this case, Maryland court. So I'm not sure. Are we getting back to Civics 101, going back? You
So
say
this-
who can take a judicial review? An interested party.
But this bill specifically says that only the legislature, the General Assembly, could take it back to the courts for an opinion. That it literally is silent and doesn't provide for a citizen to appeal this rule. If this were to pass, the citizens don't have a right to file suit because they would say, well, you have to go back to this vote.
No, Senator, I think you're misreading this provision. What this bill does is says that in these cases, which are very important, rather than going through the lengthy process of going circuit court, Court of Appeals, Supreme Court, we need speedy review. And in this case, what it is saying is if the case is important enough, the General Assembly can confer original jurisdiction on our highest court, Maryland Supreme Court. So if we have a challenge by a litigant, let me just finish, it's in play, we have the ability to say, you can go right to the Supreme Court of Maryland and get a resolution of an important legal issue, which this is a very important topic area, as opposed to going months and months through other courts. And so I think Senator, I think you're misconstruing that part of this piece of legislation.
No, actually, Senator, what I'm trying to do is I want to be very clear. So what I'm trying to be very clear on is, look, I'm not an attorney. However, I am smart enough to look at what the letter of the law and the spirit of the law is. And there's manipulation that occurs. So my question is, I'm just trying to be very clear on this, should this pass as worded in this piece of legislation, is the right to appeal this decision, or is the right to appeal any future maps triggered by the General Assembly, or can a citizen, an impacted citizen, can they file suit without it then having to go and be silenced because of this bill?
No, a citizen can absolutely file a lawsuit, file an appeal. The only thing that this is doing is allowing original jurisdiction to go right to the Maryland Supreme Court but for that litigant. And so this does not impact in any way, shape, or form what you just described. A litigant, a person, has every right to appeal a decision about a map or a decision that is adverse to what they were claiming. That's still fully intact. There's nothing in this bill that changes that, except for the fact in the redistricting context, that case can go directly, original jurisdiction directly to our highest court, as opposed to spending months going through various lower courts.
So, but that's a part of the process that we have. That is our appellate process. And now we're changing that. We're taking that away. And that's the part where people that are in my district have concerns about. Because when we're taking away a tangible element of an appeals process throughout the history of our country, that I don't know that anybody else can specify another time where we've taken away this opportunity and only left it up to what would be the General Assembly to give such sage guidance that, okay, we'll appeal this for you, because it just doesn't seem. But your contention is that's not the case. They can appeal it, and they won't reference this language here that says the General Assembly is the one that can appeal it, not the citizen.
The General Assembly is not appealing anything. It's just giving the General Assembly the ability, and it's enabling. So the General Assembly could say, no, just stick with the 8-month litigation process, but it does allow the General Assembly to let the high court in these kinds of cases hear it immediately. But it doesn't impact anything of what you're talking about in terms of the right of judicial review and appeals and that type of thing.
I appreciate that answer very much. So are we okay in clarifying that language then? Would you be okay with a potential amendment stating that we're not removing any individual's right to appeal in any part of this process?
If you have something in writing, we can review it and we can have a debate about it, but right now, I don't have anything in front of us. This is not something that we should be winging it. I made the same point in committee. Conceptual amendments, we need to have a document that we can look at, make sure it's not having unintended negative consequences in other part of the code.
Understood, and I appreciate the dialogue. Thank you for your answers.
Sure.
Thank you, Mr. President.
Thank you, Senator. All right, yes, Senator from the 31st District.
Thank you, Mr. President. Floor leader would yield.
Senator may proceed.
Yes, sir.
And just to clarify regarding the lawsuits, I don't think this prohibits anybody from putting a lawsuit. What it does, it puts it on the fast track if the General Assembly wants to do that.
Right. Correct.
But also, if there was a map that was considered partisan gerrymandering where it went across the bay and it was basing that on the Bill of Rights or the Maryland Constitution, what would happen in practice would be you have a lawsuit, goes straight to the Maryland Supreme Court. They would say, we have no criteria to base this on it, we're dismissing it. So that's the outcome of what's going to happen.
Can I just clarify that a little bit? That's not entirely accurate in the sense that our courts, and we have a U.S. Supreme Court case precedent on this, our Maryland Supreme Court can take up some federal issues. So they would have the ability to weigh in to say, is this congressional map violating Voting Rights Act? So there is jurisdiction. We have U.S. Supreme Court precedent on that. So the
I agree
answer-
with that, but you would also agree that the federal court would not overturn a map based on partisan gerrymandering.
Well, we have some Supreme Court precedent in the last few years on that topic. I mean, I can't weigh in about what some future court
No,
will
I'm
or
not
will
talking
not say. but-
future. I'm
yeah.
talking about current rulings at the federal level.
Well, they have, there was at least one case talking about partisan gerrymandering is not something they want to get involved with and that type of thing. But again, there's all kinds of provisions of the U.S. Constitution, federal law that are separate than that one specific
Right.
sort of
So
topic. So this is a complicated issue. Let me just be clear. I mean, I'm not suggesting this is all black and white, but we feel, I would say this bill, I think, is an attempt to provide clarity in a pretty confusing, complicated area, and I think it's important to provide that kind of clarity.
Right. So let's just back up a little. So the court case brought this to a head back in 2021, 2022.
March 2022.
Yeah. So
After 155 years of there not being seemingly a dispute about whether Article 3, Section 4 applies to congressional maps.
So at that point, the issue was before us. Was there any consideration by the sponsor or the majority leadership while you were putting this bill together to look if that policy was good and whether it needed to be revised to be, say, like the Maryland General Assembly, where we do consider compactness and natural boundaries?
There was no bill doing all this. All I can say is when those efforts have happened in the past, I cited constitutional amendment offerings to the populace. The voters of this state overwhelmingly rejected the idea that the standards applicable to state legislative districts and congressional districts should be the same. That's why the legislative history here is very instructive, which is why we have in part the bill here today. So I don't recall any bills doing that, and maybe some future session
No,
you
what I
can
would-
introduce a bill. I'm not quite sure exactly
be
where you're
able to.
going with this. Yeah, you won't be able to, but the senator. I keep
Right. No problem.
sorry, Mr. President, the senator
I'm
will
just
not be in
trying-
a position to put that bill in.
I'm trying to get to the history of this bill before us. So we basically had a law that was, some people interpreted one way, some people interpreted the other way.
I'm going to interrupt you. You say some people one way. That equates some parity. We have one case, March of 2022. There's nothing before or after, anything in writing, any appellate decisions. If anything, the case law is very contrary to that one opinion. So I wouldn't say it's about the both sides thing. Nice people on both sides. No, that's not the case with this particular constitutional issue.
Yeah, I don't want to get into semantics. If you have a case where one person rules one way and the other people believe the other way, you do have two sides to the issue. But the fact is, when this bill was being drafted, was there any consideration to say that we should have these boundaries for, that's criteria for the boundaries, and what we currently had before this is what we like? Or was there consideration to say, maybe we should consider this as far as a congressional map?
I think the primary reason for the bill, again, is this one decision muddied the waters, and we, as a General Assembly, have an obligation to provide the clarity necessary for if any future map, who knows when, if ever. And that's basically what this is about. I will acknowledge that one lone decision muddied the waters, but the judge herself said this is very ambiguous. I said earlier, I'll say it again, I think it was an invitation to the General Assembly to step in and clarify that language on page 16 of her opinion.
Okay, and then prior to the Shalega versus Limon case, if you had a challenge, historically, they would take it to federal court for, say, partisan gerrymandering, correct? Or do you know of cases brought to the state court on that
I mean, I think
for congressional maps?
Congressional maps. Looking for some committee counsel. Yeah, the Parrott case went to federal court.
Yeah,
I
I think that's
it's-
listed in the
yeah,
whereas. It's
yeah.
kind of all looped together. But historically what would happen would be a congressional map would be challenged in the federal court.
Which can still be the case now.
Correct. But I know you were in the committee hearing, but for the sake of the body, there was a Ruchu versus Common Cause recently, which basically said, going forward, the federal courts are not going to handle partisan gerrymandering. They're going to put it back to the states. So now what we have in essence in this bill is that we're going to follow the federal law, which is putting it back to us. And then at the same time, we're saying nothing in our state constitution or Bill of Rights can use the criteria for boundaries to determine a map as partisan gerrymandered. So it's kind of this legal trap from my research that it's basically, you go to federal court, they say go back to the state, you go to state and they say, well, we don't have any criteria. So we're basically creating a blank check for this legislature to have partisan gerrymandering with no effective challenge at the state or the federal level. And if you think there is, can you give me a concrete example?
Trying to give you a couple of concrete things here. Well, I mean, one of the rationale of that court case was the court had trouble coming up with a judicial standard. Yeah, I mean, again, some of these issues are going to have to be, will ultimately be litigated in terms of the impact, the interpretation. That court did talk about this is a tricky area. It's political, and maybe not subject to, judicial review. That's the U.S. Supreme Court. I know about that case. Look, I think it also doesn't say in that court case that you can't partisan gerrymander either. I think this is we're going to have an evolution both in Maryland and in the Supreme Court of the United States on this issue. All this bill does, I don't want to get too far afield of what this bill does, and all this bill is dealing with is, do the standards in place in our state constitution apply to congressional districts? And the overwhelming evidence from 1867 till 2022 and beyond is there's nothing to suggest at any point that that was intended, and that is the case, and we're codifying it here to clarify. I think that's really what the bill's about. I think we can go around in circles on the impact of U.S. Supreme Court cases, which again, talk about that ad nauseum, but that's really the best I can offer you for right now.
Yeah,
Senator.
and I heard the response from legal counsel was basically it has no prohibition to partisan gerrymandering. So that was the way it was before as well, if you go with the interpretation you're presenting. But a citizen had the right to go to federal court and hear it. But now with the new recent ruling, they say, no, we're not going to do that, send it back to the state. So you have this cycle where you say, go to federal court, whoops, can't do that, go back to the state. Well, we just removed it by saying nothing in the U.S. or the Maryland Constitution or Bill of Rights can use criteria for boundaries. So you've got this circle where you're basically, somebody challenges, say, you just crossed the Chesapeake Bay. They take that and say, give it to the Supreme Court. They look at it and say, we have no prohibition, we can't judge on it, dismissed.
Well,
so that is, I'm not going in, just one second.
Okay.
So I'm not going in circles with all this. I'm saying that is the impact that this basically authorizes partisan gerrymandering with no checks and balances as far as its boundaries go.
Okay, well, again, I would point out there's all kinds of other federal laws that come into play, and then also, yes.
What was the...
It doesn't authorize it, but it does not prohibit gerrymandering. But let me just... There is a solution to all this. Maybe we have a United States Congress. They can solve a lot of things, and they could pass a law tomorrow doing exactly what you say, and I'm not... we're here because we're state legislators. I get that. But a lot of these issues could be rectified, a lot of these issues, with some action at the federal level, which would provide some uniformity in the United States on some of these issues.
Sure,
all 50 states, as opposed to every state sort of doing its own thing at this point. So, I'll just have to make that big picture point here for you.
So as far as not prohibiting partisan gerrymandering. That opens it up so we can get an 8-0 map. It lays the groundwork. There is no map in this bill. I got
There
that.
is no map.
But it lays the groundwork. So let me go on to another subject. During the hearing, we heard that we cannot disarm because of the national politics. We heard that we have to have options. And I'm not really sure what all that means, but I know the rhetoric coming out of the Democrat leadership is that they want an 8-0 map to compensate for other Republican states gerrymandering those states. And so my question is, that seems a very high price to hold 3.5 million people, voters, hostage, to use it as a bargaining chip to say 80% of the population of registered voters do not vote in the Democrat primary. 80%. And if we gerrymander to an 8-0, that's 3.5 million people. And I believe the presiding officer said, we have to break this at the national level. And so it seems like we're holding these people saying, you're not going to get a voice in the process because it's already determined in the primary and the general election is already baked in. Why don't we be like Indiana and say, we're going to do the right thing and we're not going to go down that path?
Okay, again, I don't want to get into what's happening in Indiana. Yeah, I have to come back to this most basic point is we could have passed a map, but we chose to not do it this session. And I think some of the, again, I said this at the outset about if we were to ever get to a map, we could have a debate about the impacts that you're just describing. But right now it's a hypothetical future scenario that does not exist today. All that exists today is trying to clarify what has been thought to be historically the law of this state constitutionally when it comes to what standards apply. So, you know, the senator may not be here, 20 years from now if there's going to be a debate about some possible map, but you can weigh in with your senator at the time that you don't like it, but right now that's not in front of us.
And I totally agree with you. There is no map in this bill, and it's hypothetical. But what this bill does is it lays the groundwork so there are no prohibitions of partisan gerrymandering. So we're not making the map now, but we're setting the rules for when we come back to say we can bring it over the Chesapeake Bay without the courts having the ability to strike it down.
Can I use that asked and answered objection, Mr. President? Okay.
Okay, we'll go on to another one. So I heard you talk about the court case back in 2022, and the majority party, the attorney general, whatever, decided not to appeal it. The way it's being presented in the committee and today on the floor is that you're very confident with these hundreds of years and all that this is the way it is, it would stand the test of the Supreme Court, et cetera. Got that good stuff?
Okay,
So-
I yield back to you, Senator.
So my question is, the body or any attorney general did not appeal it at that point, where they could have put this to rest. This past January and throughout our session, the presiding officer said, and I quote, when talking about the governor's commission maps, which were pretty well gerrymandered, coming across the Chesapeake Bay, and I quote, he says, "They are objectively unconstitutional and jeopardizes Maryland existing maps." So if your position, or if the position of this body, committee's position, is that it's so slam dunk for hundreds of years and all that, why would the leadership publicly go out and say the governor's maps are unconstitutional?
Okay, I'm not sure what you're referencing. I really can't get into
Daily Record. It was
Okay,
a quote.
I'm not going to rely on. I respect the Daily Record, but that's not. I'm just going to reiterate, not super germane to what we're talking about right now. I don't know what comments you're referring to. I don't really want to get into that.
Okay. My point there was that if we're so confident that the higher court would go back to the previous interpretation, why not adopt maps and let the courts take it up and then take care of it instead of taking it away from, or putting it back? I guess you're putting it back. So let me go on to another question. So this bill came in amended, correct, from the House?
There was one amendment that was put on the House, correct?
Okay, and can you explain for the body what that one amendment was?
Yeah, I may yield because it has some implication for a Senate bill that we passed earlier this session. Senate Bill
I'm not trying to
29.
get in the details of it, but just generally what it did.
Well, right now there are some timelines in place for constitutional amendment language that was passed, I think, in some legislation this year, and it has some deadlines. And so all this does is simply allow the ballot question to go forward, has some language in there to that effect, and it's going to go on the ballot. And I think, again, the senator was a sponsor of some legislation that established some of those deadlines that were they're in there. But I mean, I think we had this lengthy discussion in the committee. With the
My
vice chair
colleague's
want to
going to
yield.
ask more detailed questions. I don't want to get in the details at this point.
Yeah.
But not with the timeline and so forth. But one provision of this, under standard drafting, when you have a constitutional amendment, there is a review process of the language to make sure it's substantially similar, they can tweak it and so forth. Part of that amendment that were just referenced removed that accountability, and it just let the legislature determine the language, who obviously has a vested interest in passing this in the public. Why would you want to take that oversight, not you, why would this amendment want to take away that review?
Yeah. Let me.
Could the floor?
Can I just yield
Great.
to the vice chair, because she was very involved with the piece of legislation from this session. She was a sponsor.
I recognize the vice chair of the committee.
Thank you, Mr. President. Thank you, Mr. Chair. Senator, the July 1st deadline was not something we could meet because of the date that this special session was convened. So the amendment was needed to be sure that the specific words that this body hopefully will be passing soon will be what the voters will see on their ballot in November.
Okay, I'll just leave it there. Thank you, Mr. President.
All right, thank you, Senator. Recognize the minority leader.
Thank you very much, Mr. President. And might the vice chair continue to yield, because my questions are more specific to that, if that's all right?
Will vice chair yield to a question? Senator may proceed.
Yes, of course.
Thank you very much. You know, a lot has been talked about what the language is that will be in the Constitution, what the language is that will be on the ballot, and what the intent is. Okay? I mean, I think what a lot of the concern is, what is the intent of all of this? Why are we being brought down here? And obviously, from the governor's comments, we know why we're being down here. We're being brought down here because they did not like the Battaglia decision on where it stood, and they thought the best way to get around the Battaglia decision is to change the Constitution in the state of Maryland, therefore leading to a position that eventually congressional boundaries could be gerrymandered to get an 8-0 favorability to the Democrat in Congress. And that's you know, the governor's been pretty clear on what the intent is. But as we've been talking, there's so many different components to this that I want to be at least clear, if we can be, on what we're actually doing here, right? Because as you look at the bill, okay, and everybody's kind of been focused on the ballot language, but the actual change to the Constitution, right? That's Article 3, Legislative Department, line 14.4, right? The words following that, that's the change to the Constitution, correct? That's what, when we look at and pull up the Constitution of the state of Maryland, we will see this new language in the Constitution. Is that accurate?
Depending on whether the voters approve it, that would be correct.
Okay, so that language talks about each legislative district, and then we're adding, for the election of a member of the Senate and members of the House of Delegates shall consist of adjoining territory to be compact in form and of substantially equal population, due regard shall be given to natural boundaries and the boundaries of political subdivisions. So we're changing the Constitution to make sure that it is extremely clear that that's how legislative districts will be drawn, correct?
Senator, I'm going to yield back to the
Okay.
chair of the
Yeah.
committee.
We'll get-
I thought it was my understanding that you were going to ask about Senate Bill 29 about plain language, and I'm happy to
We'll
to
get
address
back to, okay, thank you.
Okay, so
So-
could
so-
you repeat?
Yes, I want to get back to what we are actually doing here, and we're,
Can I just, before you go, just one other thing. Maybe I should have made this point earlier. What we're doing here is aligning with virtually every other state in the United States, which says in almost every other state, it is the state constitution that controls state legislative maps, and federal U.S. constitutional law governs federal maps for Congress. And so we, then back to the outlier opinion there, that is basically the landscape in the United States of America. Okay, with that, I yield back to you, Mr. Minority
okay,
Leader.
and so even if we're following that line, again, going to the actual change in the Constitution, what we're going to see, not the ballot question, not the intent, not what people are what this campaign is going to look like once this is potentially passed, but the actual language will say that each legislative district for the election of a member of the Senate and members of the House of Delegates shall consist of adjoining territory to be compact in form and a substantially equal population. Due regard shall be given to natural boundaries and the boundaries of political subdivisions. That's how we're going to draw legislative districts, correct?
That's current state constitutional law.
Well, if it's
Or-
current, then why are we adding that language in there?
Okay, just again, where are you reading? Where are you looking?
This is the actual change to the Constitution of Maryland
No,
on
but
page 2 of the bill. After all these whereas statements, I don't know where those came up with, but after all those statements, the actual change to the Constitution is
Yeah, but it's a restatement of. I apologize. What line? I apologize. Where? Okay. Yeah. Okay. Well, that's.
new language in this bill.
It's not really new language. It's clarifying. That's the existing Article 4 section, Article 3, Section 4
Correct.
criteria, and we're simply clarifying it again to make it quite clear that these provisions under the state constitution deal with the election of a member of the Senate and member of the House of Delegates.
Okay.
So it is simply saying what we
So-
believe is already the law, but that's
Okay.
one of the points of the bill is to clarify that fact.
We've come down here for 2 days, maybe 3, to make sure that we're being abundantly clear on how legislative districts are drawn. Okay, we're being very clear about that. How are congressional districts drawn?
Well, you have, again, we've got constitutional provision on that. There's
Which Constitution?
the United States Constitution dictates that, and I think I even mentioned earlier there's a distinction between how we do state legislative redistricting versus congressional map makings, in which case with Congress you have a bill and it's subject to veto, whereas with the state legislative maps it's a resolution. It's a whole different, that's another point why when you look at state constitution Article 3 Section 5, it's pretty clear it's distinguishing. So the congressional map making is a process outlined in the United States Constitution.
So is the United States Constitution then just as clear on how congressional districts should be drawn? Because the congressional districts are drawn by this body, right, in the form of a piece of legislation. Right. So is the U.S. Congress as clear as this is now on how congressional districts are drawn?
That's subject, again, under federal law in the United States Constitution, Voting Rights Act, parameters, equal protection
Actually,
clause.
it's not subject to all of that.
Well,
Mr. Chair, because
congressional maps
we
are.
draw the maps. So what rules are we following when we draw congressional maps?
We're making sure that they're not in violation of the United States Constitution, equal protection, Voting Rights Act, federal law, and all those. That is what this bill reasserts, as opposed to the state constitution, which lays out in Section 4 of Article 3 the provisions that you just read. I
It's
don't
just-
know that I can be I don't know that I can say much more than that, but
It's very interesting that, again, we have a bill titled the General Assembly and Representatives in Congress, and yet all we talk about is the Maryland State Constitution on how legislative districts are being drawn.
because the point of the bill is to remove the ambiguity created by one lone case that suggested that the state constitution Article 3 standards in Section 4 apply to congressional maps. That's the whole point of this bill.
And the body believes that it is abundantly clear how to draw congressional districts? I mean,
It's not about abundantly, I'm not going to give abundantly clear. There's standards. We have to. That's what this bill does.
Okay, and keep in mind, because again, that bill, the way that congressional districts are drawn comes from this body. It will be in the form of a piece of legislation. Do congressional districts have to consist of adjoining territories? Do congressional districts have to be compact? That's
we've been doing congressional maps for decades.
Correct.
Some have been challenged, some have not. But the reality is it's subject to all the parameters that we just talked about, subject to court review and all that kind of stuff. I mean, the idea that, going back 100 years with congressional map making, that there are standards under federal law. In the U.S. Constitution. I think that's basically how I would answer it.
So in going back, and again, as we go for it, one does not think it's confusing that we have not addressed the specific requirements on how congressional districts are drawn now that we've come down here for 2 years.
I said this before, the United States Congress can weigh in on how, some of this stuff, and that's,
but assuming
that's federal law, and we will comply with federal law, and presumably federal courts will comply and review maps under federal law, Voting Rights Act, Equal Protection Clause, and all that.
So we're really down here really just to define, essentially, how legislative districts are drawn, because that's what this says.
No, that's current law. We're simply clarifying in this bill that these provisions do not apply to congressional maps. That's all this bill does.
It doesn't say that.
Well,
it just says that. I'm talking about what the Constitution will say if this gets passed. It talks about how each legislative district will be drawn. Okay.
Well, because this bill embodies what we believe to be the current law of the land in this state.
Okay, all right, and that's fine. I just want to make sure that that's what we're talking about. That's the part of the Maryland Constitution that we're going to amend. Okay, in doing that, now we have to get this question that obviously is very confusing. We have to get this out to the public, and that's going to be the questions that I have with respect to the ballot.
Okay, could I? Is this pertaining to the ballot?
Yeah, that's fine.
On this one, I'll yield back to the vice chair.
So now, Madam Chair, Vice Chair. So now we have the second part of this bill, which is the constitutional amendment question, right? Because that's exactly what it says. It says question. There's a little blank there, and it'll get a number probably right after the one we just did, constitutional amendment. So we all know it's a constitutional amendment. So this says the proposed constitutional amendment clarifies that certain standards in the Maryland Constitution apply to districts to be used to elect the members of the General Assembly. It's just what we just talked about. So again, the question talks about members of the General Assembly, yet some reason we're down here talking about representatives to Congress. How does that question let voters know that they actually are really answering a question based on congressional districts?
With all due respect, Senator.
Just reading the question.
Yes. Colleagues from your side of the aisle are talking about congressional districts. That's not what this is about. This is about clarifying language to address a court case from 4 years ago and to smooth the way if this body takes action at some point in the future. But in the meantime, there are no maps, either congressional or otherwise.
I'm talking about House Bill 2100.
Yes, sir.
That is entitled Election Districts, General Assembly, and Representatives to Congress. So we certainly are talking about
There are
congressional.
no maps associated with this, nor will the voters be considering a map.
I didn't say that the voters were being considered a map. I don't think I mentioned that. I said that the question says that the proposed constitutional amendment clarifies that certain standards in the Maryland Constitution apply only to districts used to elect members of the General Assembly. So this has nothing to do with congressional districts?
When it comes time that this body looks at drawing new congressional lines, which is not what we're doing now, the process will be governed by the United States Constitution and all federal laws, as it is in all other states.
Okay. Okay, so when the time comes, and that's my next question, when does the time come to draw congressional maps?
Well, the Constitution says decennial after the census, but this President of the United States has changed that process, and many states have followed his
What form has he used to change
Pandora's
that?
box,
What-
and so a number of states have taken action. Maryland has not, because we needed to go through a thoughtful process in order to anticipate possible legislative challenges.
So regardless of what the President of the United States did, the General Assembly puts in the piece of legislation that changes congressional maps, right?
When and if it chooses to, and the votes are there.
Okay, so the General Assembly can do that at any time? It could do it every 2 years if it would like?
I'm not going to speak to that.
No, I'm
that's,
just
that's
asking-
not what's before us.
No, could it?
Hypothetically,
Yeah.
hypothetically,
Under current law? It could be done every 2 years?
I suppose.
Okay, all right. That's interesting, okay. But just in the past, we've only done it every 10 years so far. We've waited for the census from the data to come in, and that talks about reappointment, I believe, or
The United States Constitution talks about a decennial counting of every person, after which time laws are considered and written.
right,
drafted.
because that dictates based on the population, how many
Congressional
seats, districts.
It redraws our lines, county
It doesn't
council.
redraw, it just tells how many seats each state will have, right?
That is the first part of the process.
Right.
Yes.
This body redraws the lines?
Yes.
Okay, all right, that's
Yes.
what I wanted to make sure, because the census isn't doing that. In the legislative session just passed, we passed a piece of legislation, Senate Bill 29, we talked about that a little bit already. Just to make sure I understand, because obviously we made some very specific changes on how ballot language is determined. And there was a number of steps that were required to do that. The first step was the Secretary of State shall prepare and certify to the state board the information required for all statewide ballot questions and all questions related to the enactment of the General Assembly, which is petition to referendum. So the first step is the Secretary of State. And it used to read, no later than the 95th day before the general election, but now we made a very specific change to say on or before July 1st, immediately preceding a general election. Why was that change made? I'm just trying to remember Senate Bill 29. Why was that changed? Why was it taken from a number of days beforehand to very specifically July 1st?
The reason for the July 1st date was a combination of the beginning of the fiscal year and enough advance notice. 90 days would not allow the Maryland State Board of Elections to comply with the UOCAVA, the Help America Vote Act for our troops, our people who get our ballots in the mail. So we had to back things up a little bit to make sure that the ballot language went through the process, was analyzed, publicized, reviewed, commented on by the general public, and then would be finalized and the ballots could be printed. So all of that is why it started earlier.
Right, so we made changes to the time frame of the Secretary of State's office to July 1st. The State Board of Election used to have 10 days after that, but now was also required to meet their requirements before July 1st. Then it goes into county attorneys and municipal attorneys. If there's any questions that are specifically related to them, they all have to have this done by July 1st. after that, then we added new language to say the state board shall make the information submitted in accordance with the subsections above. That's what we just talked about.
That is this new law,
Yep.
SB 29.
Make it available to the public for a 15-day comment period, right?
Yes,
That's what we just put into law. Because obviously we thought that it was very important for these types of ballot questions to be put before the public, so maybe we could get comments from them, right?
that's correct.
And because sometimes these ballot questions could be confusing, right?
The goal of this new law is that they wouldn't be
I was
confusing.
Just going to give you credit for that, Madam
Yes,
Chair.
thank you.
Vice Chair,
This
that-
body started passing it back in 2020. It's
That's
been
right.
around a long time.
So we wanted to make sure the public could read what we're doing, right? That all of this language that we've been talking about, the language that's going to change in the Constitution, the language that's on the ballot, we wanted to make sure that the public could understand that. So we're going to give them 15 days to make this available to the public for comments, right?
That's correct.
Okay, that's great. So then, following that, the State Board of Election is going to review the comments received during the comment period and make any necessary changes, right?
That's partially right. So if you go to the State Board of Elections website, you'll note that there are 10 counties, starting with Anne Arundel and going down through Wicomico, that have ballot measures. And those links, that language, proposed language, is on the website right now and that deadline for comment just passed recently, just last week. There is also an SBE, the State Board of Elections, and that's statewide. So the county ones are considered by the county attorneys. The State Board of Elections, the statewide ones that come from us, go through the Secretary of State's
Right.
office.
And I'm sorry, I did skip that part with the county attorneys and
Yes.
the municipal attorneys
Right.
because that's not what we're dealing with. But you're right, you changed the bill to make sure that we're on the same time frames. But the point I'm concerned about, again, is after this 15-day comment period, okay, then then you're right, the person required shall prepare a statement.
There's 4 days after the comments are submitted. The Secretary of State or the county folks can then review, consider the comments, and then suggest or publicize revised language
Right.
if needed. And again, those are all posted on the website. We were
Right,
going
right.
for transparency.
So after this comment period, a 15-day comment period, where we're allowing the public to take a look at the work that we're doing here, or the county work, whatever, but let's assume that the work that we're doing here, the Secretary of State's office could actually make changes, right?
And they did on actually one of the questions. Question 3 is now modified.
Okay. So what type of comments could be brought before the Secretary of State's office that would be enough to say, hey, you know what, we want to change the wording that the General Assembly put before us because we read the public comments?
Well, again, your question isn't quite precise enough here. So if the language that is drafted by the Secretary of State is imprecise or incomplete and during the public comment period, suggestions can be made. They can reconsider, as they did with this one question about the vacancies on the Commission on Judicial Disabilities. They added a segment that I think is better and then finalized it. The difference in this, since we are here to talk about House Bill 2100.
Let me just, because I want to compliment you.
Okay.
Good job, right? We did a good job. We put a piece of legislation out that we passed, and we said, you know what, we want the public to take a look at the work we're doing, and if they don't understand it, they can make comments, and the Secretary of State's office can make those changes. Okay? So,
Correct.
So good. We did that. We've given that opportunity to the public to take a look at this type of thing. So based on that, once that's done, go ahead. You want to go? Yeah.
There are
Sure.
two versions of legislation, and I just want to flag for that. So you will notice, if you go to the website, there is right now questions 1, 2, and 3. And those are done. They were completed before July 1st. They were subject to comment and all that. This has missed the July 1st deadline because of the date of our convening. So the rules are a little bit different, and Senate Bill 29 envisioned and anticipated that.
And where did again, I have the bill, but where did it say that if the legislature misses the dates here, that this...
On
the-
page 7, lines 13 through 15, and I'm just going to read them since it's one sentence. It talks about for an enactment of the General Assembly referred in accordance with Article 16 of the Maryland Constitution, the enactment. So it's the specific language. It's not going to be rewritten or reviewed or commented on. It is just the language that we enact here. If we enact by 3/5 majority and it goes to the ballot, it goes directly with our language.
Okay, so that's interesting. The part before all of that, section E, talks about the state board and each applicable local board shall post in a manner widely accessible to the public for at least 90 days before the general election.
We're good with that. If this bill, if House Bill 2100 moves forward, we have plenty of time. We are much more than, well, barely more than 90 days before the election. So we
we're
are in
about
compliance.
24 hours before 90
Yes,
days.
August 5th,
Right,
tomorrow.
because 90 days before the election is August 5th. Okay.
Correct.
So again, we've found a way to kind of, and I'll say circumvent, but we found a kind of a little bit of a loophole here.
I'm going to suggest, Senator, that we found a way to comply.
Found a way to comply. Very interesting. Let me how we're going to comply with this. Section 7103 talks about that each ballot question appear on the ballot containing the following information. And number 6, which we added, says a brief statement explaining what the practical outcome of each voting choice would be.
Yes, and I think that's going to be very helpful to voters.
Yeah.
One of the things that I talked about and that you may have heard is there were 400,000 people in 2022 who voted for governor and then did not express their opinion on a ballot measure. That's because they found it confusing. So when we make it clear, here's the implication if this passes or fails. So that is what we will start seeing on the ballot in many cases.
All right. So when does this get completed?
It's already on the website that I have mentioned a few times. I told you there are 3 questions now, questions 1, 2, and 3, and they are all
And each one of those questions
Compliance.
has a brief statement explaining what the practical outcome of each voting choice would be?
Yes, Senator.
Okay.
Would you like me to
Nope.
pick one and read?
Nope, not as
Okay.
concerned with those 3 questions, I'm sorry, but I'm concerned with this one. So if this legislation gets passed tomorrow, which is the 90th day before the general, that's another question. And I know you're one of the experts. What is considered to be the general election? The date of the election itself, election day, early voting starts, mail-in ballot starts? What is election day, and how is it defined somewhere?
Senator, I
Or election.
suggest that everyone in this body knows when Election Day is.
I'm sorry, I misread. It just says before the general election. It just says immediately preceding a general election. So it didn't say election day. So my apologies. How is a general election defined?
When the polls close at 8 p.m. on Election Day, the first Tuesday after the first Monday on Election Day, that will be Election Day.
But if
And then
something-
it gets certified after that, but that's Election Day.
If something needs to be done preceding a general election, is that general election considered election day? Is that what you're saying?
Thought we just both agreed that August 5th was 90 days before the general election. So that will be tomorrow. That will be 90 days.
So I wanted that confirmed, that when everything talks about a general election, we are not talking about when early voting starts, we're talking about election day itself, correct?
I think I already
Okay,
answered
all
that
right,
question.
I'll take that as correct. Okay, so going back to my question then, if this were to pass, and we're now at 90 days exactly tomorrow, who and when is preparing the brief statement explaining what the practical outcome of each voting choice would be?
What you see in this bill is what our voters would see on the ballot, period.
I understand that. Then when it says here, each question shall appear on the ballot containing the following information, it says a question number, the letter, a designation, all of these different things. But it does say, number 6, a brief statement explaining what the practical outcome of each voting choice would be. So when it says each question shall appear on the ballot containing that information, is that information on the ballot?
It will not be for this measure. It will be for the other measures, and that's because of the July 1st deadline.
So in section 7103B, it doesn't say anything here about missing deadlines and not having to comply if we miss a deadline.
The House Bill 2100, as before us, makes clear that this is the language, precisely this is the language that will be on the ballot. No adding, no amending, no deleting. This language.
So could we go back to voters and say that the brief statement explaining the practical outcome of each voting choice will not be available to them on this ballot question?
On this one ballot question, that would be correct, as has never been before.
Well,
This is all new.
But this went into effect June 1st.
Agreed, it did.
That we thought this was important enough to do and put it into effect right away, and now we're going to miss the first deadline. Well, I was giving you credit before because I think a lot of this is good, but I think the fact that we are rushing something to get done and therefore missing a requirement, I want to make sure that we are not obligated to still meet that requirement.
We are not.
Okay. And Mr. President, if I could just quickly take the opportunity to thank the Department of Legislative Services. I'm going to read a fiscal and policy note, but I really do want to thank them for all their efforts. I know, 2 days here, we were under the tight time frame of trying to get some amendments done and things like that, and they've done an outstanding job of doing that. They took a lot of requests that we had to put in legislation, and they were very polite in their response, saying that they were not allowed to draft the legislation. But as always, I think the Department of Legislative Services does an outstanding job in helping us to have the best discussions available for what we're talking about. It's always interesting to read the fiscal note on what a piece of legislation does. And when we've talked about plain language and the question that's going to be on the ballot as opposed to the actual change to the Constitution, and then we have the Department of Legislative Services, and Department of Legislative Services says, the proposed constitutional amendment, if approved by the voters at the next general election, establishes that nothing in the Maryland Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional districting plan. So that's what we talked about before, that we're saying that there's nothing in anything within the state of Maryland that will determine how we draw boundaries for congressional districts. Is that right, Mr. Chairman, if you don't mind yielding?
Okay, why don't you restate that question?
Nothing in the Maryland Constitution, including the Declaration of Rights, provides applicable criteria for the boundaries of a congressional districting plan.
Yeah,
That's pretty plain language, right?
It is clarifying.
I think a lot of us would like to see that language on the ballot. It makes a lot more sense because guess what we're talking about here? We're talking about congressional districting, right? Because that's what we're here for. That first statement does not even mention legislative districts. It just mentions congressional districts, which is the title of the bill. So it's interesting that the Department of Legislative Services, in describing what this bill does, talks specifically about the congression. Now, so I don't know why that language isn't what we're seeing as the ballot question. Nothing in the Maryland Constitution, excluding Declaration of Rights, provides applicable criteria for the boundaries of a congressional districting plan. Obviously, there was no fiscal note to this. Recently, we've required racial and equity impact notes. There was no note for that as well, too. That wasn't discussed, anything with respect to what Department of Legislative Services provided.
That was not.
Okay. My goodness. You know what, Mr. President? I am done. Thank you very much. Thank you, Mr. Chairman.
Okay.
Thank you, Madam Vice Chair, as well, too.
Say perfect time. Can we please ring the bells, Madam Secretary?
Mr. President.
Just a moment, Senator, just one quick moment. If we could please ring the bells, make sure that we have quorum. Can we do a quorum call quickly?
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 44 members in the Chamber of Quorum being present, the Senate of Maryland remains in session. Let's recognize the Majority Leader.
Thank you, Mr. President. Pursuant to the provisions of Senate Rule 77B, debate on House Bill 2100 shall be limited to 120 minutes in the aggregate for consideration of second reading and third reading and final passage, and on all subsequent questions, amendments, and motions so related to such motions, readings, and other actions. The President shall allocate the 120 minutes aggregate time among those senators desiring to speak thereon, provided that not more than 60 minutes shall be allocated for the proponents and not more than 60 minutes shall be allocated for the opponents of such a bill.
All right, the Majority Leader has moved to limit debate.
Point of order?
It's not a debate. Senator May.
Understood. Point of order, Mr. President. We've had several hours of debate in the other body yesterday. And this is a really important measure, so we're going to do the vote now on limiting debate.
We are going to follow the rules just like the Minority Leader thought that we should.
Minority Leader has a quick question. Just a point of order. Because we're still on second reader, so there will actually be time taken to call
all subsequent debate. As the motion from the Majority Leader and as passed out in written form is for all subsequent action on the bill.
So does the time that it takes to call a vote and push buttons and all, does that count on timing?
Specific procedure is not when speaking, that would count towards.
Okay, thank you
for
very
debate.
much.
For debate. It's only on the debate, not the procedural. All right, question is on the motion to limit debate. The clerk will call the roll.
Mr. President?
Has everyone recorded their vote? Anyone wish to change their vote? Explain their vote? If not, the clerk will take the call. With 31 votes in the affirmative, the motion to limit debate is approved. Recognizing the Minority Whip, we are still on second reader. The question is on the favorable committee report. Recognizing the Minority Whip on the report. All right, or on the report. Any discussion on the report? If not, all in favor of the report say aye. Opposed, nay. The ayes have it. The report is adopted. Amendments to the bill or its title. Recognize the senator from the 37th has an amendment.
I was standing to speak on the report.
Oh, I'm sorry. The senator have an amendment? Are there amendments coming? Technically, we don't have anything before us, but
Not at this time. I believe there's another.
I think there might be
senator that
amendments
has an
coming
amendment.
if the desks have anything to say. Yes, okay. I recognize the senator from the 31st has an amendment. Our wonderful pages who are stepping in from the Secretary of the Senate's office will collect and distribute the amendment wearing the retro page jackets, which found from the deep back of the closet. Not gray. These are the old school gold. All right, Senator, just give us one moment to put it up. And obviously this doesn't count towards any of the time, so just want to make sure we have the right amendment. 422, clerk will, all right, Senator may proceed on the amendment.
Thank you, Mr. President. As the committee will know, I tried to put this amendment in the committee, but we had to get this out to the floor, so they said do it on the floor. And first, I want to congratulate and thank the Vice Chair. She has championed plain language so voters could understand what's going on. So this bill has been amended to strip out certain portions related to the ballot question. And it was explained that the timing required that amendment to be in there so it would meet the timing requirement. So what this amendment does is it tailors that amendment, and it says keep all the timing requirements in there, so it falls under the exception, but it restores the normal standard review by DLS and so forth, and also incorporates the newly enacted plain language that we passed and thought it was important that voters would understand what they're voting on. And that's the amendment.
All right, Senator moves the amendment. Let's hear from the Vice Chair of the committee on the amendment.
Thank you, Senator, and thank you for the kind words and for your support in committee and on the floor. Plain language is a good thing. This amendment, though well-intentioned by the senator, is actually just not feasible. There is no time to comply with the plain language, with our new law, because July 1st is in the rearview mirror. So there is no time to have the Secretary of State draft language, to have it published, to have comment period, to have it modified. It's just not an option, which is why this bill, as modestly amended, will make sure that we see this language on the ballot in November. I urge my colleagues to vote no on this amendment.
All right, thank you, Madam Floor Leader. Yes, recognize the Senator from Lower Eastern Shore on the amendment.
Thank you. I had questions for the maker of the amendment.
Question for the maker. Senator may proceed.
I just wanted to understand just the process here. As I understand it, your amendment would allow the process that is outlined in Senate Bill 29 that includes the 15-day comment period. That would include, your amendment would allow for that 15-day comment period. Therefore, if your amendment is not passed, it shuts out the public from that process.
Correct. The plain language would not be put in the language. It would also, there's a second part where DLS or the Secretary of State reviews the language that the General Assembly put forth for their bill to make sure it's accurate, and they can modify it in a small manner to keep it. So you would have no review, as is the standard process for all the other bills we put forth, and you would also have it in plain language so the people would understand what they're voting on.
So the people would have no option then if they're shut out from that process.
Right. They would be stuck with the legal language here.
Thank you.
All right, on the amendment, further discussion. Yes, recognize Senator from the 43rd District.
Thank you, Mr. President. On the amendment, I also oppose the amendment. Just to be clear, the 15-day public comment period does not apply in this particular situation, as that the language has been drafted by the legislature, not the Secretary of State.
All right. Further discussion on the amendment? If not, all in favor of the amendment say aye. Aye. Opposed, nay. No. The noes have it. Further amendments to the bill or its title? Further amendments to the bill or its title? All right. If there are no further amendments to the bill or its title, House Bill 2100 is hereby ordered passed for third reading. We are going to check in with the Majority Leader. We are going to recess for 20 minutes. We're going to recess for 20 minutes. All right, so, excuse me, I'm sorry, 15 minutes, 15 minutes. So if we could recognize, let's do a quick quorum call.
Mr. President?
Has everyone recorded their presence? If so, the clerk will take the call. With 41 members in the chamber and a quorum being present, Senate of Maryland remains in session, recognizing the Majority Leader.
Thank you, Mr. President. I move the Senate of Maryland stand in recess for 15 minutes.
All right, without objection, so ordered. 4:24. Let's see, that'd be 4:25. 4:25. See you then.